All right. Thank you, ma'am. Ladies and gentlemen, distinguished guests, esteemed faculties, and dear students, it is with great pleasure and excitement a warm welcome to our keynote speakers for this session at International Conference. Today, we are privileged to have with us Professor J. Nuret, Professor, who is University at Macau, China. We have thus Dr. George Isaac Torres Manrique, Dean, Faculty of Law, Wisdom University, Nigeria. We have Mr. Grant Rana, Partner, Rana.
Suparna ma'am.
Yeah, I'm sorry. I think technical glitch has let my... Ma'am, am I audible now?
Yes, yes.
Okay, sorry for the inconvenience which is caused. We have Mr. Vineet Vij, Group General Counsel, Tech Mahindra, Delhi. We have Professor Engobo Amish, Head School of Law, University of Bradford, UK. Their insights and perspectives promise to inspire, enlighten, and challenge us navigate the complex international on comparative law. Please join me in extending a warm welcome to our esteemed keynote speakers. Thank you for joining us today, and we look forward in listening session with this Professor, University of China. To his credits, I would like to go with the head of Department of Global Legal Studies at University of Hello. May I begin, ma'am? Is network disturbing everyone? Or it's...
Yeah, in between, we are not able to hear you.
Yes, it's not clear. We're losing out sometimes. Yes.
Okay. All right, I'll take apologies. I'll switch over to the better network connection meanwhile. So I was going by the credits of Professor Rostan Jenurit, who is the head of the Department of Global Legal Studies at the University of Macau and is a legal scholar who engages in research on a variety of contemporary global governance issues on various links between law, language, and technology. In his recent book, Sir has shared the challenges posed by an posed by an era of artificial intelligence, which is an effort to stimulate a transdisciplinary and transnational debate among readers. He has been the member of UM Senate Standing Committee along with the program coordinator of Master's Postgraduate Law in International Business Law. To go with his teaching abilities and criteria which he has listed is with reference to worldwide, and so it is WTO and regional trade law. He has shown an incline towards the transactional law, business law in BRICS countries, IP law in creative economy, European Union trade law, amongst few. So over to you. So.
Can you hear me? Yes. Good afternoon.
Thank you so much, sir.
Thank you very much for the kind invitation and kind introduction. I'm really happy to talk in this conference. Comparative law has for a long time been very close to my interests, my heart actually, and my life. So I will be glad to share a little bit of my most recent work that you have already mentioned, based on my interest in artificial intelligence in particular and the regulation of it. And I will briefly start my screen. I hope you can see. Can you all see the slides?
Yes, sir.
Very good.
Yes, sir.
Yeah, I will try to talk about comparative law and the global regulation of AI, because I think we are in an interesting global time. Generally, the 21st century has been very interesting already in its few years, but also most recently, we have seen the media, even academic publications, speaking about a global race for AI regulation, which sees in particular the United States, but also People's Republic of China, the EU, and many other countries trying to tackle these challenges, because we have seen gradually a change from a global race for the development of AI, where everybody wanted to be competitive in this field and still wants to be the number one. But at the same time, there were some ethical concerns and greater awareness about potential risks and dangers related to the AI, which has now triggered what has been called a global race for AI regulation. I personally think this narrative is wrong in many ways, because if it is, and this is what I'm trying to show, a matter for global concern, it should not be a global race for AI regulation. It should be a race for global AI regulation. This is a small difference, but that makes a huge difference in the end, I believe. And I don't like these kind of martial terms like battles or races and so on. Instead, we should also not look for who is first. We should look for the best solution to tackle these challenges, because there are many. And one of them is also related to time, in the sense that we need to make sure that the laws will be future-proof, which means that they don't get immediately become obsolete because of the fast development of these technologies. So it is known, here a small overview, that in the past the efforts have increased in terms of regulating AI. First, there were some ethical recommendations by the OECD and notably by UNESCO in 2021, which I will come back to. But I would like to start with the European Union. The Commission in 2021 launched this proposal for an AI Act. And that was the first time that a very comprehensive law at the regional level, in the case of the EU, was launched. And I think it triggered an important debate in which we still are. And then China also first issued some non-binding norms and ethical recommendations, and then also followed up with some sectoral laws on algorithms, on generative AI most recently, and on recommender systems. And then the US also last October, the President of the United States issued an executive order on safe, secure, and trustworthy development of AI. And this is the context in which we are. And I want to first go back to these early recommendations by the OECD, which I think already in the first recital of its preamble states that AI has pervasive, far-reaching, and global implications, because it transforms basically societies, every aspect of our lives. And I think this is an important statement, which is a good starting point for also arguing that we need some global AI regulation on top of national efforts. And the UNESCO recommendation in 2021 also is even more important, because it is a more universal international organization. At the time, 193 members agreed on this very important document, because it is very comprehensive and casting light on not only the positive but also negative impacts of AI on every aspect of our lives, and including the human mind. I want to point that out here already, because I will come back to that as well, because it forms an important subject to the need for a comparative and interdisciplinary study of this phenomenon. I also want to mention here that the recommendation takes note of the Sustainable Development Goals agreed in 2015, because AI will also play an important role in either achieving or not achieving these Sustainable Development Goals. And on top of it, even the Sustainable Development Goals in 2015 already did not talk explicitly about AI, but they mentioned, of course, information and communication technologies and the interconnectedness which I think is already a very global issue per se. So I think we should first of all, and that's also a comparative challenge in many ways, not only talk about the global governance or global regulation of AI, we should link it to, in particular, the global governance challenges as summarized, I think, very well in the 17 Sustainable Development Goals, which will also come to an end very soon in 2030. And I think it is therefore necessary, and we're going to have this fall a summit by the Secretary General of the United Nations to basically look for a follow-up, a successor kind of set of objectives for the future. And I think these two should be aligned because they have a lot in common, AI and sustainable development. And I want to show here some of those aspects, how they relate to each other and what they have in common, which is a bit of a comparative exercise already. We know sustainable development has 17 goals, and AI has been also like linked, not only like already the definition of AI is very difficult to agree upon, but it is also linked to many other technologies, and in particular, it has an all-pervasive cross-cutting nature relating to many other technologies, and I will show that too. And there's an interesting commonality. It has been recognized also here in this article, for example, that AI is going to be very important for achieving the Sustainable Development Goals. And I will show in particular that we see here AI will take a central role. And here's a first conceptual challenge that both kind of problems pose to regulators, namely that we have 17 Sustainable Development Goals, which means we need to make sure that we enact policies which do not leave one goal behind. That's why I always say, actually, it is only one Sustainable Development Goal, namely to achieve all 17. And the same is true now for AI. We cannot regulate AI in isolation of other technologies because it is a cross-cutting issue. It will be used in and is already being used in every aspect and in many technologies. And linked to that, we can just think of the Internet of Things, which will also reach out. The whole big data issue is important. Also, clearly, other technologies, neurotechnologies, and in particularly also, I think, augmented and virtual reality technologies will play an important role. And all of those are tending to converge. And here, too, we must be careful not to hamper, on the one hand, the development, innovation of AI, but we must also be serious about the risks and existential risks they may pose. So there is a commonality, I think, in between them. And what is also interesting, you mentioned in the introduction that I have an interest in language and law. And in fact, this is also a good way to look for, like, I mean, the law acts through language in many, many cases, mostly, and it is good to look for commonalities even from a linguistic perspective. And interestingly, they also share another feature, namely both of these concepts have been qualified as oxymoron, which are contradictions in terms. Artificial intelligence, because it is a kind of term that opposes or juxtaposes, brings together two opposite terms considered, like one a human element and the other one the machine, and intelligence having been always understood as a privilege of the human being and not machines or objects. Sustainable development is also a kind of oxymoron because it brings together change and not change in one word. Sustaining things is to keep them the same. So how do we keep things the same while still developing, changing, and improving upon the things we want to improve? This is a common challenge, which is no coincidence, I think. And I want to show that in particular with the next slides, that already in 1995, there were two authors, James Rosenau, political scientist, and Charles Handy, a philosopher or economist, who both independently, apparently, of each other published pieces calling the 21st century the age of paradox. That's what Charles Handy did, because he said the paradox has become the cliche of our times. The word crops up again everywhere as we are looking for ways to describe dilemmas and problems and challenges. And also James Rosenau called it actually the challenge of the 21st century being to discern powerful tensions, profound contradictions, and perplexing paradoxes. And paradoxes, oxymora, they are synonyms in many ways. They refer to dilemmas and contradictions between terms of apparent opposite meanings. And that is what prompted me myself to look into that, whether in the law too, we have many of those terms, and increasingly so. And here in this book, I already did a very interesting interdisciplinary comparison in a way between the use of these terms, not only in jurisdictions around the world, whatever I could find, case law, writings, also in laws, etc., but also in the arts, and then in different sciences, like in the economy, we have creative destruction or the cultural industries, all these terms being qualified as oxymora, political science and law. So I found them in all the different fields of science, even in advertising, in daily language. It is very common to make use of these oxymoras, like soft law or even simple products like iced tea, frappuccino have been qualified as such terms. So there seems to be something true in the prediction of these two gentlemen, which I tried to confirm in 2018 when the book came out. And then it is true that paradoxes have been used increasingly also to address regulatory problems. So David Held, for example, he said one of the big characteristics of the 21st century is also the paradox of our times, that we have more and more global issues. We just came out of a global pandemic, but we address them in very local, weak, and incomplete ways. And I'm afraid the same might happen also with AI if we do not focus on global cooperation in this field. And the same has been said about the age now of the Anthropocene, where humans are the dominant force in the planet. So it's strange if we are the dominant force, we cause all the problems, but we can't solve them. Another paradox that we are in control and not in control at the same time. Here are some examples of when we should intervene, which have also been termed as paradoxes, in a sense that if we deal with new technologies, there's always a hype in the beginning, then we forget about it, and then we underestimate it maybe in the long run. Or it also means that we are hyping it, we are rushing to regulation, and then the regulation is either outdated. The EU faced that problem because they launched it in April 2021, but then the large language models, ChatGPT, came along, and before the law has been agreed upon, and then there were ongoing debates, and it delayed the whole project, and it has just been agreed about 3 years later. And it is dangerous that, again, new technologies will come very soon that may challenge again even this act. So this is another coincidence or not. I think it is not. All these aspects I have summarized in a very short moment show, I think, that we do need not only recommendations, we need globally binding regulations at the national level where they will happen, but also at the global level. And I just want to show why I think so, because in the EU Act, there's one clause which proposes to prohibit even certain AI because they're very risky. And I'll focus only on the first one, on which I've written a book, namely that concerns AI systems that can subliminally manipulate human thoughts and therefore kind of influence human behavior without people noticing it. That's what subliminal, that's what it means, namely that you are not aware of it. And AI is, according to news reports here, getting better and better at mind reading. And we also heard in the meantime, I think Elon Musk now also not only connected a pig brain to computers, but now also implanted a chip, one of his startups at least. And I think this kind of sanctity of the privacy of thought is endangered, in fact. And here you see also in my book, I already mentioned in 2022 that privacy of thought might be an oxymoron in our time. We might no longer be able to shield our privacy of thoughts. There's also a book by Nita Farahani, who again calls it that there is a battle going on and that neurotechnology is interfering. And that is just one aspect. And there has been even a UN report on the dangers for the freedom of thought. And I think this is a very global and a universal problem, and therefore should be addressed like accordingly also at the global level. So this is just one aspect I have singled out to show that this is necessary. And here, in just looking at this specific problem and taking this one sentence from the AI Act, how to prohibit certain AI systems which might be able to subliminally manipulate the mind, we need to also engage in a very broad comparative and interdisciplinary study in a way, or use the comparative method to look not only at legal challenges, but also what does the definition of AI, for example, what does it mean, subliminal AI systems? We need to assess that from a technological perspective, which AI systems are able to subliminally influence the mind. To that end, we also need to know a lot about cognition, about psychology, and namely which senses are we talking about? How many senses do human beings have? For example, for my book, I was like reading up a lot of things and I could not find answers to that. We need really a very broad debate and an inclusive interdisciplinary debate. And I think the lawyers can here provide a framework and especially a comparative method. I will not dwell too long on this. And that also requires for everyone, actually, for every field is challenged here. And I see a greater engagement now between different branches of society, branches of technology, because of this trend of a convergence of different technologies. And this is just the beginning, that AI will be linked with various neurotechnologies, with like health devices that we're wearing, the Internet of Things, where data are gathered, and all this can be combined and is being combined to get basically a very complete image and profile of every person individually, which we already know can be used for not only neuromarketing, but also for the manipulation of elections and so on and so forth. So the AI is posing a serious challenge, but it's also a great opportunity, because I think nobody can say that she or he is not going to be affected by it, and is already affected by it. In fact, we are all affected by it, and we are all equal in that sense. We are sitting in the same boat, because this is a global challenge, and we need to recognize that. And that's why I'm calling for not a global race, but a race to the global regulation of AI. And I just want to mention here also what can be derived from that, what I have derived from this research, which was actually prompted by a linguistic comparison and in a way a linguistic data mining, that I looked into so many oxymora, found not only sustainable development or soft law or many other terms, but also AI or virtual reality, synthetic biology, many latest terms of the most important technological innovations now are qualified independently. And that's the interesting thing. It's not me who says, oh, this is all our oxymoron. No, you can find yourself literature from different fields, experts in the brain sciences, in economics, in physics, everywhere. This term seems to pop up indeed, and it indicates, I think, that we are facing a new challenge, which means in the age of AI, I think it means that we should see AI not only as a technology that is enabling us, but also a technology that is like a mirror to us. And in fact, this quote here below shows that I think an underlying motivation to study AI is to learn more about how the human brain functions and how we function, because this is one of the great deficits. I think that we have developed great external technologies, but we do still not know enough about ourselves and how to engage with each other. And that is, I think, something we need to learn. And we also need to learn, I think, how to deal with paradoxes, in a sense that contradictions, and this relates in particular to law and cooperation at the international, at the global level. Like my former supervisor, Professor Glenn, wrote in a book, Law and the New Logics. He had a chapter where he quoted actually from a Conflict of Laws book in one edition, where he said, laws may differ, but they do not conflict. The only conflict is in the mind of the judge. And Professor Glenn was a great comparative lawyer. I've learned a lot from him and his book on the world's legal traditions. And he also kind of qualified and defined comparing as a process of a peaceful coexistence. And we can use that really, like for law, we have to find ways that the laws are not in conflict, are not contradicting each other, or even where the contradictions are, This does not mean, on the other hand, that we need to have uniform laws. There is still enough room for diversity and contradictions, but we must, and that's the cognitive challenge for us, how we think, that a contradiction doesn't mean it is impossible in reality. But that is, I think, what we need to learn from, and this is no coincidence that so many technologies, phenomena we encounter and we give them the name of paradoxes and oxymora because we need to learn how to deal with contradictions. And I think comparative law can point the way in this. And with that, I thank you very much. And I hope there are some questions perhaps. And I hope I didn't exceed the time. So thank you very much.
Thank you so much, sir. It's an honor to hear you and your thoughts on AI and sustainable development goals. I am not able to see any chat over here, which has dropped a message for questions. I think if you permit, sir, we can have this session question answer round at the end, if you say so. All right. I'm happy to have a little version of over here in a consolidated manner. You said it so exhaustively, covering the artificial intelligence and sustainable development goals with 17 sub-themes. You have raised a concern that we should have one SDG covering all the 17 themes. That is marvelously said. And the sustainable development oxymoron, which quantifying and modeling the incompatibility of sustainable development goals. It has really bring out and will be bringing more changes and how we can remain same. The ongoing statement, which has led a new remark to anticipate the prospects for global governance in the decades ahead. It is required, which will lead into discern powerful also, if not governed nicely and responsibly. Your contribution towards the paradox of Anthropocene and control, which is again a new remarkable line, which I'll be quoting and unquoting, sir. Humans in control and not in control at the same time. So how we are able to establish ourselves, this has developed and raised a quest that we need to have a binding regulation, but not just at national, but at a global level also. With this, you have covered it with so exhaustively to categorically you have set it with legally sense. We have to cover psychologically and technical also, so that we can have a full dimension of artificial intelligence, which is leading into brain computer interfaces at every sector, which can be a sense to us. And undoubtedly it is a need of an hour to have the best for the answers for AI, to how to learn human brain functions with. And sir, I would like to cover up the audience also with this marvelous line, which has made me also to think and rethink again. That is, laws may differ, but they do not conflict. The only possible conflict is the mind of the judge. Very well drafted it is, and that's how we are opening the session for the next. Thank you so much, sir. It's an honor to have you with your thoughts.
Thank you.
Thank you, sir. Yeah. I believe George, sir, has joined. Thank you so much, sir. Yes, he has joined now. Okay. Sir, can I have you over here? George, sir, are you here? Are you available? Sir, please acknowledge if you are here. Can you hear me?
He is here, I believe so.
Ma'am, can you please coordinate? I think he is not acknowledging, might be facing some problem.
Yeah, I believe so.
Meanwhile, if we have any questions, please pen down in the chat list so that question answer round can take place at the last. We have covered the aspect of AI artificial intelligence, and if we are ready, we can have the second round also. Jane ma'am, if you allow, we can have the rearrangement in the schedule if he's
Yeah,
doing
yes,
well.
I believe we can go with the next speaker. We can go with the next speaker.
Yeah, Vikrant sir, are you here?
Yeah, good
Sir,
afternoon.
I request you to have your session prior to the George sir, if you allow.
Definitely, I mean, I'll be happy to do that, yes.
Okay. Thank you so much, sir. To honor Mr. Vikrant Rana, sir, I would like to go with your applause also, sir. Please, Vikrant Rana is the managing partner of SS Rana and Company, a premier intellectual property law firm of India. Sir has read the law at Delhi University in 1996 and is enrolled as an advocate with Delhi Bar Council since 1996. He is an advocate on record with the Supreme Court of India in 2006 and registered as a patent agent in 1998. He has been litigating in all courts over India, primarily at the Supreme Court of India, various high courts across the country. Trademarks, Registry, Patent Office, Intellectual Property Appellate Board, and Copyright Board of India. As an experienced IP attorney, Sir spearheads the team at the firm, which includes the specialist in law, chemical, biotech, and electronic sector. Sir has majored in economics. Sir has in-depth understanding of micro and macro factors influencing the business. With his business understanding for over a decade, Sir is providing practical legal advice also to many Fortune 500 companies and some of the world's most esteemed corporations. He is mainly into sensitizing awareness on intellectual property rights in India and is associated with several government organizations, including DFAC, Department of Science and Technology, Patent Facilitating Centers, Patent Information Centers, FICCI, Ministry of Small Scale Industries, to name the few. Sir has authored multiple articles also in legal magazines, journals, including Managing IP, World Intellectual Property Review, to name the few. Sir is also nominated by esteemed clients for his ILO Client Choice Awards of 2012. Sir is nominated for the Managing Partner of the Year by Legal Era and ALB SE Awards. He is acknowledged by every single luminary by the name of Mr. Vikrant Rana. Over to you, sir, now.
Thank you so much for that kind introduction. I really appreciate that. I'll just share my screen.
Yes, please.
Is the PPT visible?
Yes, sir.
Okay, perfect.
Please, sir.
First of all, thank you so much for the kind invitation to be part of this really global international conference on comparative law. I would be speaking on the impact of artificial intelligence on the legal profession. And as we have seen in the last 1 year, and we are likely to see in the future, the AI would have a significant impact on the legal profession. But is it a bane or a boon? That time would tell. And like any new technology which comes in, it's always a double-edged sword, which would have pluses and minuses, which can affect anything, including the legal profession. So what is AI? AI in some numbers, use of artificial intelligence in the legal profession, case studies on use of the AI in the legal profession, issues arising out of ChatGPT and AI hallucination, legal implications in terms of IP rights, ChatGPT's generative content causing copyright infringement, AI in the domain of legal research, legal profession, the benefit in the legal discipline, and emergence of alternate legal service providers. Are they a challenge to the legal industry? And some initiatives by the Indian judiciary using AI and using of AI by the IPS offices across the world. So I'm trying to cover how AI could affect and impact various legal domains, right from the judiciary to the IP offices to the legal profession itself. I think our Minister of External Affairs, Shri S. Jaishankar, rightly said that India is preparing for an era of artificial intelligence and the arrival of new tools of influence. And in the last year's budget, we had seen that they had come up with the Center of Excellence for AIs. So Indian government is really on top of things to see what all they can work in the AI domain. We have seen the recent deepfake controversies where the government has come up with notifications immediately. So though, I mean, I always say that law follows business and law follows technology, and it would be always a reactionary rather than a proactive step. But how fast we are able to react to such changes shows the government's commitment to these particular changes and challenges. In this, I could also refer to Prime Minister Modi's address to the joint meeting of the US Congress, where he said that AI is not only AI of artificial intelligence, but also America and India, which would be leading in the next number of years, and which would be a space to watch out for in both the domains, as in the countries and the AI itself. Coming to Goldman Sachs, the survey they had conducted, and they estimated that generative AI could automate 44% of legal tasks. And I was at a conference recently, and one of the in-house counsels did mention that the work they were managing earlier, a lot of it is being taken over because of the AI processes, and they were able to cut down on the headcount significantly and increase productivity at the same time. So it is a real threat, but if we look at it as an opportunity, it is also a big opportunity for the legal profession to ensure that we are keeping up with the times. And if we are on the right side and we are on the more intellectually stimulating work, it is unlikely to affect us in the short term. So we have to keep up with the times and keep learning how it would impact us and how we can try to be a step ahead of that. So what exactly is AI? AI performs frequent high-volume computerized tasks. It adds to intelligence. It achieves accuracy. It adjusts to the new technologies and performs human-like tasks. AI relies on deep learning. So these are different ways, we can see that AI is growing, and how it is doing a lot of stuff which earlier humans were doing, and it has in fact started thinking to a certain extent and analyzing documents in a much better way and able to be more accurate with the deep learning it is performing. Some numbers on the AI fronts. Since 2000, investment in AI startups has grown 6 times. Generative AI could raise global GDP by 7%. And like I said, Goldman Sachs, they said 40% legal tasks could be automated. They also predict that the investment in AI is to soar up to almost $200 billion by the end of 2025. And 80% of the organizations worldwide claim that AI is a top priority for their business processes. So we see that it is something where everybody is looking at it and seeing how they can either ride the wave right now, or at least keep a watch how it would impact and affect the profession, and accordingly adjust to that. So coming to use of artificial intelligence in the legal profession, there are a number of tools now which are helping the professionals in their different aspects of legal service providers. So like the Westlaw Precision by Thomson Reuters, we have seen that this AI assisted research tool claims to provide relevant answers to legal questions. It provides and generates research on a legal point and provides on-point cases. Its precision research feature claims to enable to search, filter, and browse more efficiently. And the AI tool also has a feature to identify the specific point of law in a case that has been invalidated so that other valid points of law are not missed. Then there's an AI sanctioned by DLA Piper. DLA Piper is one of the big global law firm, and they have developed this AI tool that claims to scan millions of communications in a few minutes using neutral net technology. The tool is primarily used by the firm to spot risk of cartels within an organization's internal data and communications. The AI tool is pre-trained and monitored by DLA Piper's lawyers on wealth of real-world data sets. DLA Piper also came up with an AI tool called Co-Counsel for tasks such as legal research, document review, deposition preparation, and contract analysis while keeping data safe and private. Similarly, another law firm, Latham & Watkins, had in the year 2017 announced the use of AI-based Kira systems for review of documents for M&A and other transactions. So law firms have been looking at different AI tools to see, automate, and make it more productive, and probably have more information which is more useful through the use of AI systems. In fact, the Indian judiciary has also delved into using AI tools, such as the use of AI tools to transcribe proceedings. In February last year, the Honorable Supreme Court of India in a hearing had used AI to transcribe its proceedings, and a screen displaying the live transcription of the proceedings was placed in the court of the Honorable Chief Justice of India. Another remarkable AI initiative by Indian judiciary was launch of Supreme Court portal for assistance in courts efficiency, SUPACE. The AI-based portal was launched to assist judges in legal research. It is not designed to take decisions, but only to process facts and to make them available to judges in a more relevant information. Then we had a case coming from the Punjab and Haryana High Court, where in a case of a bail application, Justice Anup Chitkara used ChatGPT while to pronounce his order. He did not rely on the information which came up, but he mentioned that it was only to have a comparative jurisprudence on bail jurisprudence. So it was basically to do his own research regarding the similar issues on bail jurisprudence in different jurisdictions. But the order was obviously not based on the ChatGPT research, but on the facts and merits of the case itself. And the court also mentioned that any reference to ChatGPT and observations expressed are simply meant to offer a larger picture on bail jurisprudence where cruelty is a component. So we see that they are using it, but obviously not for deciding cases on merit, but to have a more background, more inclusive, more exhaustive information on the matters they're dealing with. In a recent case, Justice Pratibha Singh of the Delhi High Court, she mentioned about that accuracy and reliability of an AI-generated data is still in the gray area. This was in the case of Christian Louboutin versus the Shoe Boutique, where the plaintiff, in order to corroborate plaintiff's reputation, contended that their reputation could be evaluated on a ChatGPT query, wherein when asked whether the plaintiff was known for spiked men's shoes, the ChatGPT affirmed that the plaintiffs were known for their iconic red-soled shoes. So the court observed that ChatGPT responses showed that the said tools could not be the basis of adjudication of legal or factual issues in a court of law. So it's important, especially when using AI tools, how you are asking the prompt questions are quite relevant. If you can actually guide the AI to speak or look at some kind of an answers which would be useful to you. So therefore, the court is very, very cautious in taking something which is generated from chat itself. But again, on a different aspect here, we see that prompt engineering would become a big thing in days to come. And especially when you're looking at legal research, then prompt engineering and the lawyers, I mean, we could see some more, more professionals coming into this particular domain of prompt engineering, and the lawyers coming together to ask the relevant questions for the generation of information from using AI tools. And I think this is one of the most important cases we have come across on the US use of AI. And this was in last year in June, when in the case of Roberto Marta versus Avianca, a New York lawyer, Mr. Schwartz, faced a court hearing when it was found that his firm used AI and ChatGPT for legal research, and the references he had made, the citations he had used in his arguments did not even exist. And he himself said he was shocked that these citations were not there, and he had relied on ChatGPT for the research to find cases which could be helpful to him. And I believe he was made to pay a cost of around $5,000 for this. And though he prayed to the court not to pass an order detrimental to the interests of the clients, and they had taken full responsibility, and they had to pay a huge cost for being not cautious enough to while submitting any documents to the court. Sorry, yeah. So issues arising out of ChatGPT and artificial intelligence, like plausible sounding but incorrect information be supplied by AIs like ChatGPT, because they would keep generating information, and it could be some plausible sounding, but the information, the authenticity or the veracity of the information would still have a big question mark. So it's important that when you are submitting anything or you are researching, that information which is generated by AI tools is also again verified. And I won't be surprised if there would be further tools which would check, what the information generated by AI is correct or not. And so we believe that use of AI tools, especially for patent revocation matters or patent infringement matters, that would be still a starting point, considering the secrecy or the confidential nature of IP rights, especially patents. But in case of an infringement, ChatGPT or AI tools would be more helpful to conduct the research. However, it has to be taken with a pinch of salt, like in this example where a law firm experimented with ChatGPT and asked it to explain the patent claim and provide an analysis of the infringement by mapping the claim and the product. The ChatGPT did perform that particular task. The explanation of the patent claim was correct because it was coming from the documentary evidence there, but the analysis being made was incorrect, as ChatGPT made its own inferences to weave a storyline. So that authenticity, that veracity would again be a big question mark while using even data which is in the public domain. And I think it's important to understand that AI is still learning, so it needs clear instructions in order to get accurate results. And that is where the prompt engineers or the prompt lawyers would really come in to ask the right questions, so that they get the right information, which is authentic information and not which is generated by AI to just weave a storyline or to just give and provide an answer. So what kind of issues we can see in case of use of AI tools in our profession, at least? I think one could be a privacy breach, that we see that, especially, for example, for a patent drafting something, if you're trying to draft a patent application based on the confidential information received from your client, this could lead to some privacy breach, because the data you put on to the ChatGPT or AI tool could be shared to a broader public domain. Though now we have various enterprise versions of these AI tools, which would limit the supply of information within the intranet and not provide that information outside. But there could still be many issues of privacy which have to be dealt with before using AI on a broader platform. Job displacement and economic inequality is there, but I believe whenever there is a new technology, there is a likelihood of replacement rather than letting go people, because they would have to now upgrade themselves to see how they can be more useful. Because it is not that AI will not come; AI would come. It is a matter of time, I believe, and making it more productive, making it more accurate, more verified. So it's important that the displacement or the replacement is something which would be there. It may lead to economic inequality, but that is true for any technology in any profession, that any new tool which comes in, it would impact the people in that particular domain, unless those people try to upgrade themselves and bring themselves and learn something new, so that they are still able to provide some useful thing to the profession there. Cybersecurity threats cannot be ruled out, certainly, because if you're connected, and there could be different ways where the bad actors could also use ChatGPT to make inroads into data sets also. So this cannot be ruled out. Use of AI tools, ChatGPT, for misinformation, that again cannot be ruled out. That is a fact we need to be aware of. Deepfake technology, I think we've seen since November a lot of news on the deepfakes. I think, and these are something which will not go away. Again, law would be there to two steps behind, looking at how to check that. We'll have change in the law, but I think it's more of a technological issue also. And from our personal practice, we have seen that a lot of patents being filed in the domain of identifying deepfakes. Even the creation of deepfakes, how they can be prevented, or like the three big, I think the camera optic companies, the Japanese, the Sony, Canon, and they are Nikon. They are working on technology to prevent creation of deepfakes, or some way to authenticate or verify this is not a deepfake image. So those issues we'll definitely see. And I think what I would add here would be the bias. Use of AI in the bias in a different way, which we have not seen till now. Where I can give an example, there was a question regarding insurance company payments being made out, and it was programmed that if the car is a red colored car, the premium would go up, because people who drive red colored car are more likely to have accidents, more likely to speed, and more likely to have accidents. So that was a bias which was pre-fed into the AI itself. And somehow when this algorithm was being tried to use in Japan, it didn't work out well, because where in Japan the color red was taken to be a positive color, people would prefer to have a red color, and so this bias worked against that particular jurisdiction. So similarly, there could be different kind of biases where people can be profiled on the basis of their color, their gender, location. So those biases, we have to ensure that these biases don't come in when AI is being used in the legal profession by lawyers or the judiciary, that we are able to see and ensure that these biases don't creep in. I think I've talked about the Avianca case. So that was AI hallucination, where and there was a study on AI exploring the boundaries of reality, investigating the phenomenon of AI hallucination in scientific writing through ChatGPT references. And this conducted a detailed study on references generated by ChatGPT in scientific writing, and study analyzed a total of 178 references listed by ChatGPT, out of which 69 references did not have a digital object identifier, a unique alphanumeric string assigned to digital content to provide persistent information. Furthermore, 28 references neither turned up on a Google search nor had an existing DOI. The study inferred that ChatGPT sometimes generated references that do not exist or not relevant, a phenomenon called as AI hallucination. And this was really shown in the Ivanka case also. Again, from the use of AI could also result in issue regarding the AI rights. Copyright infringement could be there, where some of the information and documents stored in the ChatGPT database used for training and further generation of responses to inquiries submitted by users may be subject to copyright and protected. So the work submitted by ChatGPT may contain published or protected work. However, the citations produced in the work are non-existent. So when using ChatGPT, like I said, the verification, the authentication, both would be important. That even if the content is authentic, but are you or should you be using that content, or it may lead to copyright infringement. So we need to be aware that this may still, it may be authentic, but can you still use it? So that would be the bigger question. ChatGPT's generative content causing copyright infringement. So recently we had a lawsuit filed in the US court accusing ChatGPT's AI generative content to be infringing copyright laws. And the lawsuit alleged that ChatGPT was undertaking plagiarism as a means to reproduce or make a derivative form of content from copyrighted data material present online. And the lawsuit further contends that the developers and programmers of ChatGPT do not have regulatory mechanisms to adequately ensure compliance with copyright laws. And it raised an intrinsic issue whether the developer of the ChatGPT should be made liable, or the human involved in directing the creation of ChatGPT should be made liable. So that prompt engineer, would it be the prompt engineer? Would it be the developer? Would it be the owner? Who would be made liable there? I think there was a recent case of a New York Times, and where the prompts were so good that first of all they said how we can go around the New York Times website locks there, and they were able to give so good prompts to the AI tools that they were able to generate the same article which was there on the New York Times website verbatim, but not asking for it directly. So the prompt engineers were able to give the right prompts to get the article so that they could use it without paying or without offering credits to the actual article and the newspaper. So that was the negative, but coming to the benefits I think are again like a bane or a boon. We see, they would be really helpful in legal research and analysis. It would be cost effective, time saving, efficiency being enhanced, and document and contract review. So there would be a lot of benefits, which would lead to a transition of the legal professionals also from what they're doing to a different set of things they would do in the future. And like I said earlier, it is a matter of time. It is something which will stay and which will only improve in the times to come. And as lawyers and as the legal professionals, we have to be more ready to adapt and adopt to this changing times, so that we also grow with that. Responsible use of AI and ChatGPT in legal discipline. While benefits are significant, it's crucial to consider the ethical and practical challenges. Challenges that come with its use in the legal practice includes issues, like I said, about accuracy, bias, and confidentiality. Legal professionals should ensure they're using AI tools responsibly and ethically, leveraging the benefits while mitigating potential risks. One more thing I could add and to this would be that I think in times to come, there would be a requirement of disclosure on the parts of the legal professionals that when they have drafted some pleadings or they have done some research, then they do disclose that this research or this something has been done conducting use of AI. So that kind of disclosures would come in, and we'll see how it really develops from there. So one last thing before I end would be on the emergence of alternative legal service providers. We as legal professionals, we have number of services being provided to clients, but we have seen that because of this technology, and there we see a dawn of this unprecedented technologically advanced era, which has also led to widespread use of technology in many areas of legal services. And this has led to the emergence of alternative legal service providers, which could also be a good avenue for legal professionals, because these would also require legal professionals, but they in turn would be in probably not all, but some activities could be overlapping with the works being done by the lawyers. So these activities of ALSPs involve providing legal services such as document review, IP management, litigation support, contract management, investigation support, e-discovery, and other specialized services. And the main driving force here would be the technology which they can really harvest to achieve their goals there. And a report by Law Society in 2017 stated that recent technological innovation in legal services highlights that legal technologies such as document assembly, automation, and AI are expected to disrupt the business management of legal services by creating new and enhanced services, bringing new ways to engage and interact with clients, challenging their current structure and economic model. So I think that's a foregone conclusion that this would happen, and we have to be aware of that, be more vigilant, and see how we can now actually upgrade ourselves so that we are able to still provide value to the client. I think the two initiatives I've already mentioned, how Supreme Court has used the transcription and the Supreme Court portal for assistance in court efficiency. So I think that would be okay. Two more slides here. And from the IP perspective, I can say that we have seen that number of IP offices world over are looking at AI. The EU IPO and even BIPO, they're looking at designing tools where AI could be used. And even our own patent office, the CG's office on trademarks and patents, they have also said that they're looking at using AI to help them in examining and using different functions of AI in managing the whole IP life system ecosystem at the IP office. So I think overall we would see a lot of changes at the times to come. It's important that we are cognizant of what would be there and looking at upgrading our information, our relevant tools to be able to go a step ahead, and especially from the information or the use of AI would be there. But at the same time, these AI tools would also require legal professionals to be operated, for giving those prompts or looking at the alternative services being provided. There also they would use some people from who would have legal background. So overall, I think it's still a positive development. There would be downsides, but I think on the overall, we would expect that AI would impact the legal profession more positively, productively, and for the ultimate benefit of the client and the whole judicial system. Well, thank you so much. I hope that is within the time limit, and I look forward to any questions and feedback on that presentation. Thank you.
Much appreciated, sir. If you permit, we can have the question and answer round at the end.
Sure.
All right. Thank you so much, sir. I think everyone must have jotted down the points because it is such a elaborative with reference to the case laws which you have dealt. You have included the every aspect which is going national at international level also. You included the budget, you included the laws which were there with reference to how government is going with it. And certainly you have made it clear that AI is not just artificial intelligence, but Australia and India, as Modi ji has quoted in his statement, flawlessly, sir, you have added that AI will add to intelligence, which shall have the accuracy also if it is going with the responsibility. You have led it as one of the benefit that it shall be adjusting to the new technologies which will perform human-like task, relies on deep learning. You have given enough examples with Westlaw Precision by Thomson Reuters, followed by ASIN by DLA Piper. It's a law firm which has also used the software, and Latham and Watkins LLP. I have jotted down the points for myself, so it was so elaborative that it has led to the Digital Supreme Court also, which has gone with the live transcription of the proceedings, which was placed in the Honorable Court of Chief Justice of India, D.Y. Chandrachud. In the case of Jassi versus State of Punjab of 2022, it has been held that a responsible use of AI, as Punjab and Haryana High Court has led, which has rejected the bail application using ChatGPT. Flawlessly, it is application where we are using the AI. We cannot limit ourselves only to the content which is being inferred and extracted. We need to apply human mind. So is being dealt in the case of Jassi versus State of Punjab of 2022. And we have got the case with reference to Avianica, which is an eye-opener rightly being pointed out, and the further slide of AI hallucination. In the case, Roberto Mata versus Aviana. Very nicely, sir, being said it, that ChatGPT, which has incomplete or authenticity of information, will always be a big question. We are going with the issues such as privacy breach, job displacement, and economic inequality with cybersecurity threats, misinformation, deepfake technology. With this, I apologize. I don't know how the internet is troubling at this part that I am jotting down the points and they are so illustrative, which has taken a time to cover the same. So you also dealt on copyright infringement, which has led into the references, but sometimes even the citation is not covered as DOI. So it is always a bigger question how we are going with the question framing also, and what about the authenticity of the same. So it is the application of mind with the machine, and as you have said it at the end that it is beneficial for the society, for everyone, but so the dawn of unprecedented technologically advance has led to the widespread use of our alternative legal service providers. Thank you so much, sir. I think most of us would have brought notes on the same. Thank you so much. Thank you, sir. Now, if George sir permits, we can have you over here, sir. George sir. Am I audible?
Yes, you are audible. I believe George is also available. We can
Yes,
see you, sir.
I think, yes, yes. So can we have you on this platform again, sir?
You can speak, sir. We can
I
see
believe
you.
sir has acknowledged. Yes, sir. So please. Ma'am, may I begin?
Yeah.
So, yeah. Thank you so much, ma'am. Thank you, sir. With this, I'll go with the brief introduction of Dr. George Isaac Torres Mandrick, who is the Dean Faculty of Law, Wisdom University, Nigeria. Sir is the president of the Interdisciplinary School of Fundamental Rights, guest editor of Law and Digital Technologies, Journal of the State Academic University, sorry, for Humanities, Russia, legal consultant with 26 years of professional experience in management positions, both in public and private sectors. Lawyer by Catholic University of Santa Maria, he is being doctorate of law and administration. He has dealt with master's degree in business and criminal law from National University of Fedrio Villarreal. Sir has authored and co-authored more than 120 books and has treatises in various legal branches with a focus on fundamental rights and interdisciplinary, which is being published in 15 countries. Sir is already a co-director of Criminal Codes of Ecuador, Colombia, Chile, and Panama. Over to you, sir.
Thank you so much, President Doctor. Very honored and grateful to AMI University, Utah Pradesh, and Edith Cowan University, and the renowned Dr. Rupender Singh. In the present opportunity, I will develop the subject cyber spaces, cyber spaces and cities for women and girls. Women and girls experience and fear different forms of sexual and other forms of gender-based violence and cities and public spaces running from sexual commitments and unwanted touching to rape and can result in crimes and serious and feminicide. Violence against women and girls occurs on a continuum from private public spaces. So a safe city must address security from a gender perspective and with an intersectional approach that recognizes the multiple forms of discrimination faced by women in their diversity. Then we have safer cities for women and girls. In this case, women and girls, violence and discrimination are compounded by the perception of fear and insecurity. Fear pre-exists in the face of situation of violence against them, so that in addition to being victims of violence, they are also victims of fear, which impedes their development and has repercussions on a broad spectrum on their life plan. In this sense, the perception of fear and insecurity of women and girls is a key and essential factor in the design and implementation of any public initiative aimed at preventing violence and crime. Therefore, beyond what a state may establishes in its legislative framework, citizen security and human security as human rights and with a gender perspective must also include the perception of insecurity and fear experienced by women in order to go beyond the physical characteristic of public space and take into account the intersectionality of both the ways of life and the dynamics and coexistence of local citizenship. Types of violence against women and girls. Among all them, we can point out first, sexual harassment, sexual assault and rape, online harassment and cyber stalking of women journalists, gender-based infanticide and feticide, so-called honor crimes, early or child marriage, forced marriage, family genital mutilation, traffic in persons and smuggling of migrants, violence against women in conflict situations, violence by a partner or ex-partner, and domestic violence murder. By the way, we have the digital violence. These are all practices that with the help of the internet and any electronic device seek to cause harm, and they can cause damage to physical and psycho-emotional integrity, stress, angst, anger, depressions, fear, anxiety, panic attacks, headache, and even suicides, damage in the social, professional, and economic spheres, social and family isolation, self-censorship, and withdrawal from activities and digital media. Then we have the digital sexual violence as an attack of women. In this regard, we have through the threat of dissemination of intimate content, then through the dissemination and the interception of communication or obtained content, through impersonation of creation of false profiles to obtain content. Sexual violence also extends to this space and coordinated attacks known as some bombing or some trolling with record, which were most exercised by men during video calls with audience of women, in which they took control of the video or screen sharing a function to show the global audience some installation of pornographic content, of even to carry out live sexual scenes, for example. Then we have uses generated by digital violence against women. On this great basis, we can see use and subtopics. Use dissemination of personal or personal of intimate subtopics. We have publication, photographies, videos, or personal data, but by authorities without prior notification or consent, which generates hostility, criminalization, or other manifestations of violence against women and digital spaces. Then leaking and distribution of intimate images without consent, situation that becomes forms of sexual abuse and exploitation related to technologies. Second, use harassment threats and their identity. Like subtopics, we have harassment threats and identity through digital media against women, but private individuals. Smear campaigns through digital media generates under the argument or regenerate under the argument of the exercise of freedom of expression. Then we have the use culture of impunity that discourages the reporting of acts of digital violence. That subtopics, we have re-victimization of women who reports acts of digital violence, obtain illegal evidence by reviving social media accounts, lack of preservation of evidence, custody, uploading of evidence. Then, like use, we have regulatory and reprogrammatic and topics. Like subtopics, we have legislative reforms. They are unclear and focused on only type of manifestation of digital violence and with a punitive approach, challenge in the regulation and liability and intermediary campaigns involving in the digital intermediaries' participation in the digital space. Then we have a Women program. Data generated by the 2020 report show a context of widespread and systematic sexual harassment and violence in a public space. We have Guatemala City, 100% of the women who participate in the study reporting having experienced some form of sexual harassment during their lifetime. Quito, 91% of the women had experienced sexual harassment in public space in their lifetime. Montevideo, 84% of women between the age of 18 and 40 report having experienced sexual harassment in public space at least once on their lifetime. Medellin, 60% of women perceive Medellin as unsafe city. El Alto, 96% of women report having experienced harassment in public space at some time on their lives, and 77% felt fear and public transportation. Institutional violence we have in some countries of the region that show the sexual violences by police, military, and other security agents is already a significant trouble. For example, in Mexico City, it has been reported that there are 2, 4, 5 open investigation files for sexual crimes allegedly committed by agents of different police institutions belonging to public and private corporation. Evidence shows that women in marginalized situation are at higher risks of suffering sexual violences and in authoritarian abuse. Women with disabilities, women with unstable housing, LGBTQ women, and migrant women. By the way, we have free and autonomous mobility. Fear, crime, and violence of a sexual nature in a public space are strongly, generally, and rationally impact women's freedom of movement. And they need then the same rights, the opportunities to occupy cities that men enjoy, strongly generated by gender and race, impact women's freedom of movement, and they need them and the same rights and opportunities to occupy cities than men enjoy. Many cities have implemented strict quarantine conditions with mobility restrictions and in some cases gender mobility limitation. These measures may further develop women's perception of insecurity public space and reduce their freedom of movement with restrictions are gradually lifted. The regulation of movement in public space has had gender basis and untitled consequence in Latin America. From example, in Panama, Peru, Colombia, it was established that women and men could leave their homes on alternative days, which led to cross to food supply points when it was women's turn to go out. This situation increased women's vulnerability to increase contagions that's different the original proposed to the measure. The regulation also pose additional challenge for trans and no-binary gender identity people who were more exposed to discrimination and violences from police force, even with their protection was officially decreased, as was done in Bogota, in Peru. Then we have a global fighting initiative, Safe Cities and Safe Public Space for Women and Girls. Several states made the gesture of making a commitment related to this use. We have themes, commitments. Like themes, we have identification and appropriation of solution relevant to the local context and population. Montevideo, Uruguay, creation of sex discrete data. Guatemala, design inclusive intervention with diverse communities. And the themes comprehensive laws and police, Manila, city ordinance to prevent sexual harassment and public space. New York, law to stop sexual harassment in the workplace. Ecuador, care protocols to ensure women's safety and public transportation. Canada, culturally appropriate care services for indigenous women. Mexico, mobility regulation helps address women's safety. In the theme safety and economic viability to public space, we have India use women's safety audits in safe public space. Egypt, improving public transportation for women and girls. Papua New Guinea, the spaces safety for women in public spaces. Transforming in the theme transforming gender and social norms, we have Colombia changes social norms at multiple levels. In Mexico, municipal campaign for the prevention of sexual harassment and public space. Morocco, community organized intervention with diverse audience. Mozambique, youth agents of change and prevention in schools. Kenya, involving men and boys in the prevention of sexual violence in rural areas. Then we have strategies for ending violence against children. Among the main strategies, the following should be noted. First, implementation and enforcement of laws, then norms and values, then safety in the environment, fathers, mothers, and encouragement and support, income and economic empowerment, response to care and support service, and finally, education and life skills. By the way, we have the strategies for changing violence against women in public space. In this regard, it should be noted that diagnosis to identify context-appropriate intervention with a gender perspective. Then develop and implement comprehensive laws and police to prevent and effectively respond to sexual violence in public space. Then invest resort in the safety and economic sustainability and public space. Then change attitudes and behaviors to promote the rights of women and girls to enjoy public space free of sexual violence. Then we have the urban environment, a restrictive space, key variants for women in inclusion in the city. At this point, it is important to consider daytime and nighttime use of public space, the importance of visibility, urban infrastructure and equipment, safety, different perceptions, women participation in public space, mobility with a gender perspective, violence against women and girls in public space. Then we have within principles for promote respect, guarantee and protect the rights of children and adolescents. Definitely, the specific principal theme gives not that we have best interest of the child, focus on the right children and adolescents, non-discrimination, life, peace, develop, survival, to hard participation, to be her participation, interculturality, inclusion, progressive autonomy, co-responsibility of family members, society and authorities, transversality, dignity, differential and especially approach, maximum protection, dignified and preferential treatment, no revictimization, treatment with respect and dignity. Then we have violence against the most vulnerable women. In this essential and to understand this group as a priority. Thus we have indigenous women, girls and adolescents, elderly women, displaced women, migrants and asylum seekers, women with disabilities, paid domestic workers, LGBTQIQ, deprived of other freedom, feminicide violence, intentional homicides and suicides, disappraise of girls or women. Then we have the inappropriate content for children in cyberspace. In this point, we can appreciate the risks, first the risk type, then description. The risk type, we have content risk. In this, the description, we have when a child is exposed to unwanted and inappropriate content. This may include sexual, pornographic, and violent images, some forms of advertises, racist, discriminatory, and hate material, and websites that advocate unhealthy and or dangerous behavior, such as self-harm, suicide, and anorexia. Then risk type, contact risk. When a child engages risky communication, such as with an adult who seeks inappropriate contact or target a child for sexual purpose, or with individuals who attempt to radicalize a child or persuade a child to engage or in healthy and dangerous behaviors. Then risk type, behavior risks. When a child behaves in a way that contributes to risky content or contact. This may include children writing or making hateful materials about other children, inciting racism, or the possibility or distribution, sexual imaging, include materials they themselves produce. Then we have the important item, this the fundamental rights that may be violated. The violation of fundamental rights is the violence against children and women. It's a matter of concern. We have fundamental rights, life free of violence. This means can use digital space safety to one's own imagine. To privacy. To honor and dignity, to privacy. Then también because to access to justice, internet access, personal integrity. For example, like conclusions, we have the use of safe spaces, or safer cyberspaces and city for women and girls requires the political will of the states, but it also requires the participation and commitment of the private sector, parents, and finally of all individuals. It also implies a more troubling study, since the current reality in which it manifested itself leads us to consider urgently turning into what is happening in virtuality, that is, with intelligent technologies, more intelligent and future technologies. It's essential to understand that interdisciplinarity contributes to a better understanding and approach of these situations. This in the understanding that the trouble that embraces cyberspaces and cyber cities for women and girls does not begin of end in the world of love. So, finally, like suggestions we have. It requires awareness training and specialization of the main actors, leaders, those involved in the administration of justice. It is essential to embrace we're favor of the fundamental rights of women and children in order to be in tune with the imperious and urgent need that such scenarios imply. It's also essential to guarantee the participation of experts in various science and disciplines of human knowledge other than law, in order to achieve the implementation of the corresponding public policy, in order to guarantee women's rights to cities. Is essential to ensure that they are planning them with a gender perspective and ensuring the participation of women in all decision-making and planning space. Thank you very much for your attention.
Thank you so much, sir. Undoubtedly, you have highlighted that aspect which is not really addressed. So I would like to go with your quotes only, where you have pointed out the difference that how the digital age is creating an embark on everyone's life. You began with the violence against women, which is an ongoing aspect, which is the part which we have to control, on cyber harassment, revenge porn, threats of rape, and then it can go and extend to the sexual assault or murder. Perpetrators also, you have highlighted that it can be a partner, ex-partner, colleagues, schoolmates, or even in the case of anonymous individuals. Predominantly, the root cause of violence against the women and girls is gender inequality, or should we consider it as sexism only? So violence against women, which is also highlighted as at a vulnerable group, which you have covered, that they can be indigenous, they can be domestic workers, any particular women who is deprived of any freedom can also have the fear, and they can be most affected ones. So you have highlighted that online abuse may limit women's right to express themselves also equally, freely, and without fear. Cyber violence, which has been affecting the women disproportionately, not only causing them psychologically, but also making them with the fear to live for their lives, which is leading in a restrictive part for the political aspect, for their social and cultural life. Victims of fear, which impedes where the state has to establish the laws for controlling crimes leading to sexual harassment. So you made the difference clear with the multiple crimes which are taking place on account of stalking, forceful marriage, and to the content of smuggling also. So which has affected the psychological impact, where they are covered with the depression, panic attacks, suicidal attempts at every phase, not only at the workplace, but the other indigenous part also. So your content on intimate part, where impersonation, false profiles, yes, rightly being pointed out that it is the one which is triggering. So states are there to control the same. You have led the difference where you have made it with the India to Mexico, Mexico to Morocco, and to the Kenya for prevention of sexual violence. So you have really pointed out that laying the importance on implementation is one part and its enforcement on another. You have figured it out that the safety and powers is required in every sphere, educational, economical, where the policing is required for the safety and security. And so is the case of the another part with the women and children. You have also made the difference clear that the children are also the ones who are using multiple applications, websites, technologies, which buy, sell, possess, and distribute the content, which is more exploitive. At the end, I would like to conclude by your saying only that there is a growing need to end violence, online violence against women and everyone, including the most vulnerable as children, because this is what they are leaving being behind. So by understanding your content, sir, I can surely say it in this manner that violence against women in digital sphere shall not remain understated and unaddressed with your address to us. Thank you so much, sir. Thank you, sir. If we are having Vineet with sir, can we have your session? Thank you so much, sir.
Vineet with sir is here, and Ngobo is also, Professor Ngobo is also here. Both of them are here.
All right, if we
Vineet,
if we
sir?
go by the Hanji. If we go by the same order, we'll have the Vineet with sir with us. Welcome, sir. So to go with the introduction of Vineet with sir, Mr. Vineet with Group General Counsel, Tech Mahindra, Delhi. Sir, you have a rich professional experience of 25 years in legal, secretarial, regulatory, risk and compliance, and corporate and public affairs. In leading information technology, IT-enabled services, banking sector, non-banking financial companies, and engineering. Most recently, sir, you are serving as Senior Vice President, Legal, Commercial, Regulatory, Compliance, and Public Affairs at HCL Technologies Limited for over 11 years. Earlier, sir, you have worked in legal, regulatory, and secretarial roles with Tata Group, Tata Unisys, Infotech Limited, and Tata Consultancy Services Limited for 10 years. Besides handling legal, secretarial, and compliance functions in Punj Lloyd Company and American Express India. Sir is a litigator and practicing advocate before High Courts of Delhi, before the High Courts of Delhi and Mumbai, and district courts and tribunals across the country, and has been witnessing to the landmark judgments passed by the courts in India and across the globe. Sir experiences with a wide variety of practice areas, including commercial and contract laws, IT, data protection, privacy, cyber, IP laws, merger and acquisitions, telecom, litigation, and arbitration. Sir has done graduation in BCom from Sri Ram College of Commerce and LLB from Delhi University. Sir is well respected in his industry for his efforts in policy advocacy and multi-layer government engagements. Thank you so much, sir. We are having an honor to have you at this platform. Over to you, sir.
So good afternoon, everyone. It's my privilege to be seated amongst esteemed panelists and exceptional minds. It is my pleasure to have this opportunity to address young and bright students. Let me take this a moment to thank Amity University, Noida, Dr. Tomar, and the team for having me part of this esteemed international conference on Comparative Law 24. Before I share my thoughts on the theme comparative IPR, technology law, and emerging legal domains, majorly emphasizing on the topic artificial intelligence and legal intersection, in my view, importance of comparative law, which is the title of the conference, has increased enormously in the present age of internationalization, globalization, and the world truly becoming a global village. Each country has so much to take from the other, lend to others in form of regulations with more harmonious laws, which is so important especially with technology and data now being all there. And we've seen GDPR in the recent time as one such example. I mean, my fellow panelists have talked about AI. It's the current buzz. As a layman, in the layman language, it means like a technology that enables system to perform tasks that would have traditionally required human intelligence. And today, we have machines doing what till recently we thought only human beings could perform. In this context, I think we must look at how internationally the leaders and everybody is really welcomed the advent of the technology. And in the words of our honorable Prime Minister, who's called artificial intelligence as a tribute to human intellectual power. I mean, that's where it comes from. Our honorable Chief Justice, the honorable Supreme Court judges, they've all pitched for adoption of AI, especially in the legal field. So what's happening? The power to think has enabled humans to make more tools and technologies. And today, these tools and technologies have also acquired the power to not only learn, but to think. I think there is where we are. AI has now become a buzzword in the last 2-3 years, but it's not something which is very recent. It dates back, I would say, several decades when computers were conceptualized, primarily revolving around algorithms for calculations. So we've seen artificial intelligence in some form or the other for several decades, but it's looking like more of a reality, or it's actually become a reality at present. Parallelly, we see in today's time when AI technology is advancing exponentially, AI has started to take over every aspect of our life. Therefore, it is crucial for every country to frame regulations around AI. This has not escaped the attention of legislatures and policymakers globally. And in past year, particularly, I would say, we've seen AI regulations model emerge. And therefore, the years to come promise to usher a new wave of AI obligations for organizations and developers and innovators. While the European Union, the UK, China, US have been on the forefront to come out with AI-based legislations, even the developing countries have AI regulation now on their priority. And therefore, I would say all of us here agree and believe that AI has the potential to significantly improve legal practice efficiency, talking more from a legal industry perspective. It can significantly improve legal practice efficiency by automating routine tasks, reducing the times required for legal research, providing real-time access to information, and therefore it will give lawyers and legal professionals more time and space to focus on more complex and value-added tasks, resulting in better outcomes for their clients. AI systems can analyze massive amount of data and identify patterns and relationships that human may miss, possible, which will result in more accurate decision-making and better outcomes for client. And thirdly, AI can be used to provide clients with instant access to information, even personalized recommendations, and virtual legal assistance. So that's where we are. From a legal intersection perspective, focusing, we had the earlier gentleman talk about legislations, and from a European Union perspective, we see EU has unfailingly been at the forefront to set global standards when it comes. And we've seen that in form of several other legislations and, which have got adopted by other countries. The European Union Artificial Intelligence Act, as we call it as the EU AI regulation rather, is the first ever law, as comprehensive, and we should be seeing it rolled out soon, at least if not this year, next year for sure. The Act aims to regulate the use and development of AI through risk-based approach. So what are we talking about? It's how do we use the AI as we go forward. So what's the act intending to do is to divide AI into 3 risk categories. Of course, one is an unacceptable risk, high risk applications, and then we talk about minimal risks. The act aims at categorizing AI systems which are minimal, so therefore with minimal risks, so they're free to be adopted without any restrictions. There is a second category from a limited risk perspective where AI systems will interact with natural persons. You talk about emotion recognition systems, etc. So that's the second category. But the other 2 big categories are the high risk categories, which will apply to, for example, the AI systems that are covered by product safety regulation regimes and that require third-party conformity assessments. Areas like medical devices, machinery, and so on. And then, of course, the requirement the Act prescribes is that the provider of these AI systems should perform conformity assessment that will include whole lot of things, from a risk assessment system perspective, transparency, and so on and so forth. And lastly, of course, is the unacceptable risk category of AI systems that process real-time biometrics in public spaces for law enforcement purposes and so on. So therefore, these are cases which are prohibited, and of course, there are fines attached to it going up to 6% of global revenue or 330 million euros, so as to say whichever are higher. So I think largely what we see is how the AI applications will get adopted and how they will be used. But what it's clearly, what emerges is we are talking of data governance, we are talking of transparency, we are talking of human oversight, accuracy and robustness, and of course, documentation and record keeping. And we talked about GDPR, how it impacted and led to world adopting data protection regime and so on. So it's generally hoped that the AI regulations will bring this kind of a de facto Brussels effect, and you will see these AI really getting regulations all across, and the world benefiting from these regulations. UK not part of EU, but of course, since it houses AI companies like Google AI Lab, DeepMind, the AI video maker company like Synthesia, I think. So therefore, they are also looking at an approach which is not very heavy-handed legislation, because I think on the one hand, you're talking about innovation, free hand to it, but at the same time, seeing whatever are the minimal regulations that need to be built in. So therefore, we've seen in July 2022, UK unveiling the AI rulebook that defines AI for general purposes and is non-identical in comparison, of course, is non-identical in comparison to the EU AI Act. The UK government has also published the AI Code of Conduct, which outlines principle for ethical and, in inverters, ethical AI design and deployment that include transparency, accountability, and fairness. The 4 principles that therefore form the basis are the context-specific around use and impact, pro-innovation, coherence, and of course, proportionate and adaptable. So that's largely we see on what's happening from a UK and EU perspective. In the US, on one hand, we see individuals, media companies, content providers already filing lawsuits, particularly against generative AI software companies such as the OpenAI, that is the ChatGPT, Stability AI, DeviantArt, etc., where the lawsuits primarily allege copyright infringement. The allegations are these AI companies illegally train various large language models on copyrighted content from that originating from other media companies. And of course, these generative AI companies have been taking defense of fair use. So I think that's the background already, and we're seeing quite some litigation already in the US. And of course, those are the incidents that happen. But on the other hand, there is no dedicated global, a legislation at the federal level, so as to say, in the United States, though we see a lot of initiatives already. So we've seen initiatives, and we could talk about, at one hand, in order to strengthen and coordinate AI research across all US, the departments and agencies, the National AI Initiative, which was established after the National AI Initiative Act was passed by the US Congress in 21. The act involves numerous US administrative agencies, including the FTC, the Department of Defense, Agriculture, to name others. And so what's really happening, therefore, is we are seeing AI regulation primarily being aimed at a sectorial level, sectorial specific level. So therefore, we have laws and regulations which though govern at the healthcare, finance, transportation, consumer protection, etc. And therefore, accordingly, various states have now proposed and or are enacting legislations on AI, including laws addressing data privacy, algorithmic accountability, and so on. So I think that's where we see the action happening on the US side. In addition to this, we also see a vast amount of data that AI relies on, raises privacy concerns, which has also the case in the US. And therefore, we are talking about laws such as California Consumer Privacy Act and even the HIPAA Act, which generally governs the collection, storage, and use of personal data. So I think that's quite some work that's already on. So therefore, in addition to what FTC has done, which has adopted AI expertise in enforcing variety of statutes such as Fair Credit Reporting Act, the Equal Credit Opportunity Act, the FTC Act, and where it's proposed to make sure that AI is trained using data, and there are no misinformations taken. The AI is properly tested before deployment. The AI outcomes are explainable. There is an accountability and governance mechanism all being built in. So in addition to what FTC has done is, there is also the National Institute for Standard and Technology, which began work in 2021. NIST has released official draft of AI risk management framework. Again, there are multiple characteristics and points in terms of validity and reliability, safety, fair and non-biased approach, explainable and interpretable. I mean, I'm just keeping it short. So I think that's what we're talking about. Of course, then we've seen in China, which has implemented regulations and around the generative AI already. The recent law passed in China supposedly is the world's earliest and a comprehensive regulation on controlling generative AI tools such as OpenAI. The Chinese government has issued guidelines on standard AI ethics, safety, and security. So I think these are common principles going across countries and so on. So I think the world thinks, and the regulators, though we do not have a regulator as yet from an AI perspective, but I think they all seem to be thinking from the same mindset. So China also has put in several regulations, namely the algorithm recommendation regulation, which focuses on use of algorithm recommendation technologies. You have a deep synthesis regulation, which focuses on how utilizing the deep synthesis technologies. Then you have the draft ethical review measures. You have the generative AI regulation, which concentrates more broadly on regulating the development and use of all forms of generative AI technologies to provide services within China. So such is what is all happening from a China perspective. And of course, at India, at this point in time, we do not have any official, so on India, we do not have as yet an AI Act. Also, we do not have an official big data repository or a disclosure requirement regarding use of big data. But we are really seeing the Ministry of Commerce and Industry, which came out with a task force in 2017, talking about AI adoption. And then in 2018, when the Ministry of Electronics, the MeitY, constituted 4 committees to develop a policy framework. And the Niti Aayog recommended in 2020, a AI explicit computer framework titled Airawat, for setting up and meeting the processing needs of innovation hubs, startups, AI researchers, and students. The principle, of course, was safety and reliability again, inclusivity and non-discrimination, equality, privacy, transparency, accountability. And then, of course, the NASSCOM, which is the, kind of a nodal agency for software companies, has also come out in form of guidelines for responsive use of generative AI, particularly how developers and researchers work and how it will be primarily focus, that the work is done in an ethical manner. So I think that's quite some work which has gone in. And of course, in 2023, we see India legislating the data protection, the Digital Personal Data Protection Act, which also, brings about a legislation which emphasizes on the nation's focus on building a strong data privacy regime. So that's what is happening. Then we also have these international organizations like the UN, the Economic Cooperation, OECD, the World Economic Forum talking about frameworks, how you have the guidelines for AI governance and work there. So I think large and large, we are seeing a lot of stuff happening already. People who talked about AI to be just one-off and would never come in, today realize that it is already part of our systems. We've already adopted it probably several years ago, and we move much forward on it. So I think there is a wide range of regulatory tools and approaches that are now available. But on the one hand, we are also seeing self-regulations where the industry participants, have not only created responsible AI principles and standards, and I can talk from an IT services and AI companies perspective, and have not only accepted these principles, but also abiding by the same. And we also have, various legislations which kind of fall in the gray line, examples like the product safety, in the product safety space, the consumer protection space, the anti-discrimination laws that we talked about, which will also apply to the products and services that use AI. So to largely summarize, AI is not a horizontal technologies. It combines various applications, but it is a dual use technologies. That is, it can be both put to good use and bad use. So therefore, we need a proper legal and regulatory approach. And this approach has to be cross-border because AI spans and crosses the borders. And therefore, apart from these regulations, there is also a need to have global treaties and conventions. Particularly, there are, gray areas of terrorism, warfare, military applications, and so on. So I think I end there. I've had my panelists talk largely more on this subject, but I think that's my small take here. Thank you.
Thank you so much, sir. Really, you have covered the aspects, how we are able to compete at the comparative part. Although there is no strict regulatory yet, but we are moving towards the same. You began with the same, that world has truly become a village where each country has so much to exchange all about the information, the technology, which is making a platform for us to contribute also sensibly. And we have to go with the liability accountability also. So you began with the statement of Modi ji's, where we are saying that it is a tribute to the intellectual minds of human. Undoubtedly, sir, you are going with such statements where we all agree with you. And AI has become a buzzword, which is recently of no one. Yes, it has dated long time back to us also, where we used to go for the algorithms. So yes, regulations for AI is required, which is at the present era we are going for the same, for accuracy, not only for one aspect, at the other level of spheres, health center, consumer wise, and so in the litigation. You have further figured it out, the legislative aspect, discussions from European Union, where the first ever law was made in the nature with reference to how to use AI wisely. And you categorically mentioned the three types of risk. I think that is the highlight of the entire discussion, which has led every single state to be a part of the same. I mean, they are making the laws how it can be adopted with the minimal to limited to the higher risk, because that's how we are approaches, that's how we are our approaches have to be for going with the freehand AI, or it has to be with the personal and emotional attachment, or it has required that aspect, which is the third party confirmation. Certainly, sir, the provider of AI should be held responsible, but for whom we are going to figure it out. You have really figured out the aspect of the data governance, accuracy, the documentation, which is a regime over here, which brings not only de jure, but de facto, how it is benefiting everyone. Your innovation, which is the aspect of freehand, to be governed with the minimal regulations. So the laws are making in the process of the same, where you are going with the establishment of UK to federal, and then you have gone covering the Indian perspectives also, although we do not have specific, but yes, sir, you have rightly pointed out that we are going with the Niti Aayog's report, and we are going with the Ministry of Trade and Commerce. Everywhere we are going to the same. And so the China has, in comparison, you did that for draft ethical measures. And towards us at world level, you cover the OECD. So certainly AI is already a part of our systems, and that's how you have concluded, because at every level we are indulged with the AI development. So whether we accept it or we don't, but it has to be used sensibly before we get questioned for our accountability. Thank you so much, sir. Thank you. Jane, ma'am. If panel permits me, we can invite the next speaker, Professor Ngobo Imesh.
Yes, we can. Professor Ngobo, if you can unmute yourself and switch on the camera.
Yeah, here she is.
Yeah, you can.
Greetings, ma'am.
Yes.
Right.
Professor.
Okay.
Yeah, hello.
Thank you very much. I think I'm having some technical issues this morning. I kept banging on it on mute.
No worries.
Good
No
morning,
worries.
everyone. Thank you.
Greetings, ma'am. Good morning. So to her applause, I'm going to begin with her introduction. Professor Ngobo Imesh, Head School of Law, University of Bradford, UK. Professor Imesh has extensive experience in higher education, both within and outside the UK. She has led the development of innovative market-relevant degree schemes, portfolio reviews, and diversification of delivery formats to cater to a wide audience, maximize resources, and improve the student learning experience, including external engagement and skills development. Ngobo obtained her PhD from the Center for Energy, Petroleum and Mineral Law and Policy, University of Dundee. She graduated with the first class with Nigeria Law School and distinction from the University of Wales, Cardiff. She is a former British Council Chevening Scholar and a Ford Foundation Doctoral Fellow. Prior to her academic career, she practiced as a barrister and solicitor in Nigeria, having been called to the Nigerian bar. To go with your research, ma'am, it is in the nature of environmental law and policy, where the particular interest in enforcement, environmental justice, corporate social responsibility, and the interface between environmental regulation and international economic law. You have published multiple papers at academic conferences and at international fora. We are happy to have you here, ma'am.
Thank you. Thank you
Over
very
to
much.
you, ma'am. Yeah.
Thank you. Thank you for that very kind introduction. And I want to say a huge thank you to Amity University, your partners, for inviting me to this conference and making it possible for me to interact with the excellent papers that I've listened to so far. I think my topic moves slightly away from what's been offered so far. I work in the area of environmental justice, environmental law and policy. And so I'm going to be talking about just transition, the energy trilemma, and environmental justice, complex factors influencing law and policy. And the rationale for this, or how it fits into this conference, is that I think some of the other colleagues have said, we find international law playing quite a significant role in the modern context around comparative law and how different countries, different regions respond to some of the emerging challenges and issues and the factors that influence the differing responses, I think, deserves study. So within the context of climate change, and for those of us who would have followed the various COPs, you would find countries being pitched against one another and perceptions around different countries' responses either critiqued or applauded based on how it affirms with what the dominant narrative is around some of these issues. But as we know, law policy never exists in a vacuum. It exists in context. And the context for different groups, different peoples would differ. And because that context will differ, I think it's important that we understand within climate discourse, climate change discourses, the law and policy surrounding that we explore how some of the principles that underpin climate policy is understood, and how countries may take different paths or different positions in what we all see to be a common problem. And so with that background, the theme that I've chosen to talk about today is on just transition, which has underpinned climate discourses since 2015, but more importantly, since the COP that was held here in the UK, COP26. And this idea that we need to transit away from fossil fuels, and if we do so, that we need to do so in a way that is just. Now, the term just transition itself is not new and is not necessarily linked or did not generally necessarily originate from climate policy discourse. Its origins is in the 1990s US labor movement. And it was led by the then union leader, Tony Mazzocchi, of the Oil, Chemical, and Atomic Workers Union. And the rationale for their adopting just transition as an underlying policy was that they were seeking support for workers to transition away from unsafe chemical processes to other processes. So in a sense, it is steeped in environment, but it was very much around the fact that as the US enacted these range of laws in the 1990s, which necessitated companies moving away from polluting industries or polluting sectors or polluting ways or processes of doing things, the workers felt that they will be harmed because jobs will be lost and the like. And therefore, they sought for a just transition where their needs will be met in that transition. Now, in that context, I think Mazzocchi said something like, we need to provide workers with a guarantee that they will not have to pay for clean air and water with their jobs, their living standards, or their future. So in a way, the same sorts of questions now exist in the current context, which is, as we transit away from fossil fuels, which is the underpinning rationale or aim of climate discourse at the moment, that we need to transit away from fossil fuels to renewables or cleaner forms of energy so that we allay catastrophic climate harm. The question then becomes, how do we do that in a manner that is just? How can we transit to renewables? How can we transit to cleaner fuels in a manner that is just? However, rather than, and because of the origins of the principle of just transition, a lot of the discourse still seems to revolve around what do we do with the workers who are going to lose their jobs, you know, and the immediacy of the issues around transitioning. Because transition would by necessity mean that the oil industry, for instance, or the coal sector will have to move to other cleaner technologies. What happens to the workers? What happens to the immediate community that relied on these jobs? That seems to be the underpinning message around some of this discourse. And we see that very clearly when we look at the 2015 Paris Agreement, where it says, taking the preamble to that agreement says, taking into account the imperatives of a just transition of the workforce and the creation of decent work and quality jobs in accordance with the nationally defined development priorities. So we see there a very clear direct link to workers' rights as part of the just transition discourse. This is also reaffirmed in the ILO guidelines of 2015, where it sort of again refers to the needs of workers, social exclusion, eradication of poverty. But the just transition discourse principle and the discourse around it actually gained traction, as I earlier said, in 2021 at the COP26 in Glasgow. And there was a specific declaration on just transition. And an initiative that was set up, a partnership, the Just Energy Transition Partnership between France, Germany, United Kingdom, United States, European Union, and South Africa, where they were saying, we will do something to support you transit away from some of your dirty industries. Of course, as part of that agreement, there was an 8.5 billion commitment to South Africa over three to 5 years to support that energy transition. However, I think the premise of my discourse are the concerns, the justice issues, the equity issues around transition beyond just workers, beyond just the communities that rely on those industries that would be transitioning. And I think that requires a better understanding of the wider framing or the wider challenges or issues around climate transitioning and climate justice. So there are three issues that I want to highlight: climate justice, energy justice, and environmental justice. And this is very much linked to what is known as the energy trilemma. And within the context of the energy trilemma, it is this idea that when we think about energy policy, we need to be aware of ensure that we protect energy security, that countries are able to rely on secure forms of energy, and that energy source should be accessible and affordable to communities, local citizens within those countries. Of course, within that context, we also have environmental sustainability, which is that we must ensure that our access to energy or our energy security takes into account the impact that the sources of that energy may have on the environment. And that, of course, then feeds into the climate change discourse. How we ensure that we can continue, if you like, to power our energy sector without necessarily destroying our environment. Be that as it may, what we do find is that these two concepts, just transition and the energy trilemma, do not necessarily always provide a seamless interaction between the other, even though the very tenet of the energy trilemma is about the equity issues, the access issues, and the sustainability issues. And that is because energy is not just about powering, if you like, the lights and the manufacturing sector, but it's very much linked to the day-to-day of our lives. So when we think about the SDGs and we think about something around poverty, poverty is very much linked to energy. When we think about access to food is linked to energy. So we cannot think about energy and a transition away from energy without necessarily considering how this impacts on some of the wider goals that we have as a global community or as a global society. So, in the context of the energy transition, you have different stakeholders and different players. You have countries that are energy producers. You have countries that are historically polluted for a very long time and whose economy are a lot more advanced and who have the technology and the means perhaps to transition more easily. You also have communities who are producers of coal or oil, for whom this source of energy is still the mainstay of their economies. You also have the communities where these industries occur that bear the brunt of historical pollution. How do we manage all of these competing and conflicting interests in the context of the wider just transition discourse? And that is where you find questions around who bears the burden? How do we go about burden sharing in the climate change context? How do we ensure that those who may have had advantages, if we are to have climate transition equity, those who have had advantages from years of utilization of dirty or industry, assist those who may not have had that benefit? How should countries who are just beginning to emerge industrially to become more developed countries, how do we address their concerns in a just manner? And of course, we all recall, perhaps within this context, that at COP26, India took a very strong stance around how we frame the transition from fossils, whether or not it was to end or whether or not we should use, if you like, weaker language to allow countries to adapt better within that framing. And then within the context of the energy trilemma, while after COP26 sort of set up this movement where a lot of the developed countries in particular and other countries in the Pacific states were very much around, we need to move away from fossils. And then geopolitics happens, the Ukraine crisis happens. And that brought a new challenge around energy security. And we suddenly found that countries that had committed to net zero commitments started to resile, including the country that I reside in, the UK, moving the dates by which they were going to be able to achieve their net zero targets. We found countries who previously had significantly moved away from the use of coal begin to go back to use coal. We found the United States again start to give licenses for exploration, for development of oil in areas that previously the Democratic government, for instance, had insisted they would never grant a license. The Joe Biden government granted that license. And that brings to fore this idea that there isn't, if you like, a simplistic resolution or answer to this very complex challenge. I was personally involved in a research over 4 years, looking at the impact of the oil sector in my home state, Nigeria, Bayelsa, the Bayelsa state of Nigeria. And from their perspective, the issues are very, very different. It's around how we ensure that energy transition does not take away the possibility or the potential for us to be made good, to be made whole from decades of oil exploration and their impacts. The whole idea around environmental justice. And that becomes pertinent because part of the transitioning is that a lot of the international oil companies are beginning to divest their interest in the oil sector. But in the course of that divestment, they haven't taken account of the historical impacts and how those will be remediated, made good, decommissioning, environmental justice concerns, remediation concerns. All of that is not part of the divestment discourse. So when, say, Shell, for instance, announced, as it did in Nigeria on the 16th of January this year, that it is going to divest from all of its onshore activities in Nigeria, that is applauded as Shell becoming, if you like, more environmentally responsible. But as part of the just transition discourse, we also know that there are several claims against Shell for historical pollution, which has not been made good. So when Shell transitions, what is the framework to ensure justice for those victims of oil pollution? And so in a nutshell, we find that that as countries make laws, policies around climate change, in the UK, in the US, in developing countries, the position that the African Union takes, the position that India takes, it is all influenced by a lot of these factors. And when we explore the actual laws, one of the work assessments that I give my students is to say, pick 4 countries, explore their energy policy. How are they addressing energy policy concerns, and link that to the just transition and the energy trilemma to begin to understand why different countries may be responding differently, so that when we assess the national responses and we kind of say this is a country that's more advanced in terms of responding to energy transition or just transition as opposed to the other, what is the framing? What are our underlying questions that we're asking? What are the issues that are at stake? And within that context, some of the questions that I want to leave with are, what is transitioning itself? Is transitioning simply about moving away from fossil fuel? Or is it about transitioning from the imprints of the fossil fuel industry? Because transitioning from fossil fuel may be easy if we find alternatives. But how do we address the imprints, the historical legacy of the fossil fuel sector? How will the central concerns of all of the different stakeholders, not just workers, be addressed in this wider framing? Can we have more partnerships along the lines of the partnership that was developed in COP16 to support some of these other emerging countries address their transitioning issues? In the context of divestments currently happening, what should be the international law response to support countries where some of these issues are happening, such that these big multinationals do not just move away and leave local communities to deal with decades of historical pollution? And therefore, the question becomes, can we have a just transition without a just environmental transition or environmental justice? And of course, the question around an equitable framework for sharing the burdens of just transition continues. How do we ensure that a lot of the commitments that are being made around supporting transition are actually upheld and honored by the countries making those submissions? And to that extent, therefore, how can nation states, Nigeria, India, Pakistan, Canada, make local laws that clearly should, because climate change is an important question, should address the concerns of climate change, but also take into account some of the local context in which it operates? And I think any exploration or discourse around these issues from a comparative law perspective would be important, taking some of these into account. And I will stop there. Thank you.
Thank you so much, ma'am. You have really covered on the climate change, and with the paucity of time, I'll not be able to bring it on record how good you were when you were explaining the need of the hour, which is requiring the assessment within ourselves, because that's how the multiple laws, legislations, not only the country's demands for the climate justice. We do need to recognize the emergency moving towards away from the fossil fuels, the framing of climate change within the global and national economic frameworks has become the part of the requirement which we do need to understand with this discussion. Thank you so much, ma'am. And I can go with this line that it's a movement together for our planet. So in this, towards our planet, we are moving further for the question answers, if we have any. I believe the chat box is empty, where the speakers were so elaboratively covering the aspect. I think they have been the thought-provoking in themselves how to figure out further. Thank you so much. And for this, as the moderator of the keynote session, I, Dr. Suparna Vinayak, Assistant Professor, Amity Law School, Noida, would like to extend my sincere gratitude to our esteemed speakers for sharing their insights, expertise, and valuable perspectives with us today. This session has been so enlightening, thought-provoking, and incredibly informative. With this, I would like to go with the citations. Jane ma'am, if you allow me to go for the same.
Is it visible?
Yes, ma'am, it's visible now. The citation is presented to Professor Rostam F. Nurit in the keynote speaker session of the International Conference on Comparative Law on Saturday, the 10th day of February 2024. Professor Nurit, a prominent scholar of international trade law and technology law, Professor Nurit's in-depth knowledge on AI law and his zeal venturing into the new aspects of law is commendable. We are highly obliged to Professor Nurit for his presence with us and for delivering a thought-provoking address. We hereby recognize the contribution made by Professor Nurit and express a deeper sense of gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you
Next,
very
please,
much.
ma'am. Now that. Thank you so much, sir. This citation is presented to Mr. Vikrant Rana in the keynote speaker session of the International Conference on Comparative Law on Saturday, the 10th of February 2024. Mr. Rana is a renowned personality with several accolades to his credit in the areas of IP and technological law. He is one of the most sought legal experts in both legal arena in academia. Mr. Rana is an erudite personality with vast knowledge and experience, has carved a distinctive niche for himself amongst the legal fraternity. We are thankful to Mr. Rana for investing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Mr. Rana and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you so much. Really appreciate. Thank you.
Thank you, sir. The citation is presented to Mr. Vineet Vij in the keynote speaker session of the International Conference on Comparative Law on Saturday, the 10th of February 2024. Mr. Vij is a legal luminary to reckon and has over 2 decades of experience with expertise in varied areas of law. We are deeply indebted to Mr. Vij for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Mr. Vij and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you so much, ma'am. It was a pleasure.
Same here, sir. Thank you. The citation is presented to Dr. Forge Isaac Torres Manrique in the keynote speaker session of International Conference on Comparative Law on Saturday, the 10th day of February 2024. Dr. Manrique is a distinguished academician in the area of human rights and political science. An academician with practical experience has been instrumental in changing the course of education through his innovative ideas. We are thankful to Professor Manrique for sparing his valuable time and sharing his insightful thoughts. We hereby recognize the contribution made by Professor Manrique and extend a heartfelt gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you. This citation is presented to Professor Ngobo Imish in the keynote speaker session of the International Conference on Comparative Law on Saturday, the 10th day of February 2024. Professor Ngobo has in-depth knowledge in the field of environmental law and energy laws, a dynamic personality with profuse knowledge and interest in research. Professor Ngobo has enriched this conference by thought-provoking words. We are deeply indebted to Professor Ngobo for sparing her valuable time and enlightening us with her words of wisdom. We hereby recognize the contribution made by Professor Ngobo and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you very much. I'm honored. Thank you.
Thank you, ma'am.
Thank you to all the speakers. We have the vote of thanks, I believe so. Yeah.
All right, thank you. Throughout our time together, we have delved into, I would also like to express my appreciation to the audience for their active participation and valuable contributions. Your enthusiasm and curiosity have truly enriched our discussion and made this session all more dynamic. As we draw this keynote session
Just a minute,
to a
ma'am.
close,
Ma'am,
yes,
Minimum
ma'am.
will be delivering the vote of thanks.
Yes, ma'am, I'm just closing
Yeah,
my
sure.
moderating part. Yeah. I acknowledge the presence of Mini ma'am for vote of thanks. So much, ma'am. I just end up in one line.
Yes, please.
All
Yes, please.
speakers' enthusiasm and our curiosity have truly enriched the discussion and has made this session more dynamic. So let's carry forward this valuable insights which we have gained together here, and with this collaborative, innovative, and striving towards excellence. Thank you. We shall be taking it to all our endeavors. Thank you, speakers. Thank you, ma'am. Over to you, Mini ma'am.
Thank you, Suparna ma'am.
Mini
Thank
ma'am,
you.
it's over to you.
Yeah, am I audible?
Yes, ma'am.
Yes,
All
yes.
right. Thank you, Suparna ma'am. Thank you, Jane ma'am. I, Mini Srivastav, Assistant Professor, ALSN, I am deeply humbled and extremely privileged to propose this vote of thanks. We had a fascinating keynote session just now with the support of some highly accomplished resource persons. We take this opportunity to thank Professor Rostam J. Newworth, Professor, University of Macau, China, Dr. George Isaac Torres Mandrik, Dean, Faculty of Law, Wisdom University, Nigeria, Mr. Vikrant Rana, Partner, Managing Partner, SS Rana and Company, New Delhi, Mr. Vineet Wij, Group General Counsel, Tech Mahindra, New Delhi, Professor Ngobo Mse, Head, School of Law, University of Bradford, UK. We are sure that all the participants, including our students, would have immensely benefited from this insightful talk. We really thank you for your time and involvement in our conference, and we look forward to your continued guidance and support to our futures endeavors also. Thank you so much, everyone. Thank you so much, participants, for joining us in this session. Thank you.
Thank you.
Thank you, sir.
Thank you.
Thank you so much.
Everyone.
Thank you. Thank you.
Thank you.
Thank you so much for joining us.
Thank you. It was a pleasure.
Thank you to all the panelists who have graced this occasion. And I think this was one of the power-packed presentation which we had in the conference. Thank you once again to all the panelists and hope to see you next year also in the 6th version of the International Conference on Comparative Law. Thank you once again to one and all present.
Thank you very much.
Thank
Have
you.
a good day.